Welcome to another episode of the Vanderbilt Political Review podcast. Today, I have our first guest for 2026, Darren Kellis. He's a freshman from Alpharetta, Georgia. And today we're talking about the two articles he's written for VPR so far and issues that surround it. Firstly, we talk about Chancellor Diermeier's principled neutrality stance, especially as it relates to questions of anti-Semitism on campus. Of course, if you were here back in 2023, 2024, you remember after October 7th, that was a big thing on campus here. And in the second half of the podcast, we discuss the recent US v. Scrimeti, or was it Scrimeti v. US? Whatever it is, decision that implicated the question of whether transgender Americans were a protected class worthy of equal protected status under the 14th Amendment. So both of those things and more in today's episode. Hope you guys enjoy. We have Darren Kellis. Did I get your name right? All right. Yeah. He's a freshman here at Vanderbilt. He's been very brave in writing two articles already. Doing very good for VPR this year. We're kind of in a glut for articles, so please write articles. And join VPR too. We have I'm not sure by the time this episode comes out, the open enrollment, if you will still be open, but as of now, it's still open. And also, this room had a flood this morning, really? So we're lucky to be in here. I almost had to cancel. That's why this tablecloth's so dirty. So forgive us for a dirty tablecloth.
Was it all the way up to here?
No, like that pipe over there. I know no one can see this, but the pipe over there burst, and it was a whole thing in here. But anyway, back on topic. You wrote two articles. We were just going over how the first one was about Chancellor Diermeier's principled neutrality, his stance on that. The second one was about the US v. Scrimeti decision, in part talking about the broader implications of that case. I was talking to you before, and I was asking you what direction you wanted to take this in. You said you wanted to mainly talk about the first one, so you can start there. So I guess we can just start by you summarizing just what you said in your article and in your general position on the matter, and then we can kind of go from there.
Okay, so I'm going to try and recount my writing process to the best I can.
Sure.
But, so the inspiration kind of started when I went to orientation for Jewish students. That was through Hillel. And they had a speech from Chancellor Diermeier, and he was pretty much specifically addressing the parents. And kind of from that speech, some policy issues came up. And I have my family's a little heated when it comes to Israel-Palestine and those kind of debates. So I didn't know what to anticipate, but I was a little worried about stuff like that kind of getting stoked up. And so I listened through that, and then he made some remarks about divestment, and it wasn't really clear to me if he was trying to make that a political statement, in my opinion. And I wasn't really sure what direction he was approaching that. But then I went to another speech that was 2 months later, and he was receiving an award from Hillel and Chabad, which is a lamplighter award, and they're basically rewarding him for the work he did for Jewish students during the anti-Semitic protests and that kind of stuff during 2023, 2024.
I was here for that.
You were? Okay. Yeah, and I have heard some controversies in talking to people and hearing about that. But so I was kind of interested to learn more about his role and what had happened. And I was listening to his speech, and he seemed to be a very strong defender of Jewish life on campus and stuff along those lines, which was nice. But then he did make a statement that was like a direct condemnation of BDS operating in campus or people supporting BDS who are...
And just for anyone who doesn't know, can you clarify?
BDS is boycott, divest, and sanctions, I want to say.
Okay.
And
general just don't deal with Israel, basically.
Okay. Exactly.
The gist.
Yeah. So it's basically mostly economic protest of Israel, and it is controversial. There's a lot of people who want to say that targeting Israel is in my personal opinion, it's not anti-Semitic because that's a different thing from being anti-Zionist, but there are people who definitely think that is controversial. But I took that as being basically a political statement because based on the works I had read from him in some articles, he had said that if a campus official makes a statement about a certain political organization or about a stance, then that would be in violation of institutional neutrality. But his argument was along the lines of saying that divestment doesn't promote institutional neutrality, and that I guess he doesn't view the issue of divestment as an issue that would violate institutional neutrality, but I'm kind of questioning how that comes about, because I feel like if you issue a statement that it's pretty clearly taking a stance on the idea of whether DS is okay to be on campus or not. And while that may be like, it may have to do with the funding of the university, and I can see where he would approach it from that angle, I feel like he's kind of suppressing and encouraging like a chilling effect on free speech regarding the BDS movement by just taking a side on that argument. And so I thought that was pretty problematic.
Right. Okay, that's a good foundation. Thank you for the summary. I guess my first question I guess I do some clarifiers first to make sure we're clarified, then we can continue.
Yeah.
So just to clarify, I'm going to pair it back to you. And if I get it wrong, just correct me.
Okay.
But if I'm not mistaken, what Diermeyer basically told the group in both instances was that the school will not be supporting divestment for X, Y, and Z financial reasons for the school. Is that correct, or am I missing something?
That's what I was believing at first, but then the second statement, I'm going to try to quote as best as I can. He said that the corrosive BDS movement has no place on Vanderbilt's campus, essentially. Okay. So
corrosive was the word?
Yeah, he said corrosive.
Okay.
That's the
I remember that word.
I know that was for sure. But yeah, so I guess he could have been taking an angle of approaching it from the school's function, but it wasn't really clear to me that he was doing that. And I thought that particular language seemed to quite pointed to me, and it seemed like it was very much taking a political stance. Mm-hmm.
So is your problem more that he's being inconsistent in your mind, or is your problem that he's taking the wrong stance in your opinion, or is it both?
Well, my personal opinion is, well, honestly, yeah, it's definitely more about the kind of hypocrisy of the situation, where I do think he's kind of contradicting his professed values of institutional neutrality by making a statement like that. And that was my main issue with that. I'm not probably the biggest fan of his political stances or his actions just in general, just to preface that. But yeah, I do think my main issue is the kind of hypocrisy of his statements and going back on in what my view is a contradiction of his earlier words.
I see. Mm-hmm. I guess one of the biggest questions is, obviously divestment has to deal intimately with the school's finances and operations, right? It's not like, I think you can understand this too, right? It's not like the school's coming out and saying, I don't know, like, for example, like that lady that was killed by the ICE agent in Minneapolis. Like the school just came out and said, like, we condemn the killing of Renee Good was her name, right? Mm-hmm. That'd be like, okay, like that's obviously like nothing, like there's no argument that has nothing to do with the school's operations. That obviously is a school coming out, making a political stance. But obviously, again, you see with this, funding does have to do with the school's operations. It's a thing that the school has to deal with. It can't avoid that question. So do you think that has any bearing on perhaps forgiving the chancellor for not most faithfully following the principle in your eyes? Or is it even, I guess the counter argument would just be like, that is not violating institutional neutrality because it's on a topic that intimately relates to the school's operations. Institutional neutrality applies to basically everything else that the school doesn't have to make a comment on. So I just put a lot there, just however you want to take that.
Okay, yeah, so, well, I think I would be a lot more understanding if the chancellor did defend his comments from like a financial perspective, and if he viewed that issue as affecting the financial operation of the university. Mm-hmm. But then I had heard a story from someone who was here during the campus events during 2023, 2024 with the anti-Semitic protests, the protests against Israel. And then,
I was going to ask, like,
I'm not calling them anti-Semitic, but like what is seen as anti-Semitic in some of the anti-Semitic incidents where students have been accused of anti-Semitism or where there have been like genuine cases of anti-Semitism. Right. But then, yeah, so I heard from this person that, sorry, I'm like blanking.
No, it's good.
Sorry.
You're trying to remember the story, right?
Yeah, I'm trying to. Yeah.
But so, what was the general gist of the of the stories that you were told?
So wait. Okay. Oh my God. So I heard that Diermeyer, okay, now I remember. So
there we go.
Sorry, that was really random. But so the student government, they have their own specific budget. And so there was a movement to essentially divest from Israel within the student budget and not within the actual university.
I remember this,
Yeah. So the argument that the university made essentially was that there's a Tennessee state law that basically prevents divestment. And so they didn't want to violate that law. But according to the actual like stipulations of the law, there was a certain amount of funding that you couldn't go over, to where if you went over that amount, then it would violate the law from divesting over a certain amount of like public funding. And so, or not public funding, but funding in an institution that has like public funds or is supported by the government. And so the amount that the student government would have divested based on their budget would not have actually exceeded that limit. So there was some controversy over why the university was not letting them make that decision when it would not have actually violated the law.
Right.
And their argument was that it was out of like extreme caution or just being safe. But yeah, I definitely would view that as, I feel like that is probably pointing in a direction where the university just would not want to allow that kind of political submission to be made.
I think what's kind of obviously going on here, at least in part, is the school doesn't want to have the image of either, I mean, obviously explicitly being anti-Semitic, which I don't think is even remotely what's close to going on, but what could have been perceived was a school being permissive of anti-Semitic actions within or under its purview happening, right? And obviously the school doesn't want that. That's not going to look good. Not only just like in general and just like generally, you know, morally, that's not a good thing. But also like in terms of rankings, in terms of the things the school also really cares about too, funding, as we were just talking about. I think we can imagine a similar thing if, you know, it'd be one thing if, you know, a student was talking critically about, you know, racial issues, right, in a very academic way. And another thing if they're just like very plain just racism right on campus. It's not gonna, the school doesn't want that look. I guess what I'm getting at is just in your mind, is institutional neutrality supposed to be a hard rule that's never violated if one's to espouse it, or is institutional neutrality supposed to be a general set of guidelines or a general goal to be sought that seeks to keep the school away from political controversies that it needlessly or has no business getting involved in?
Okay. Yeah. So I think as much as possible, it would be best if it was kind of a hard line, but obviously that can be kind of hard to define and work out the.
Mm-hmm. And if I can pause you, like why? Like why is a hard line in your mind better than a more this general goal of being generally neutral, guided by prudence, for example?
Well, I think that this is a very like salient example because, well, I would say that the movement to divest the student government funds was definitely not anti-Semitic in my opinion, and it was very much based on disagreeing with the actions of the Israeli government.
Sure,
and
so, I would agree, by the way. But
okay, yeah,
not with the action per se, but with your characterization, just to be clear. Yeah.
Okay. Yeah. So I think looking at that, it kind of, well, I'm sure the college has the reasons that they will argue do not have to do with political aims. But in my opinion, it begins to look a little suspicious when you have recurring instances of kind of evading action that seems to be anti-Israel. And so in my opinion, it just causes a lot of distrust with the university and their procedures when there's a potential for abuse like that, when there are very unclear standards and it's up to a very subjective basis. So it would be nice if there were some very clear defined guidelines, and then Vanderbilt students could be more confident that there will be consistent execution of this policy regardless of what kind of political stance is at hand.
Mm-hmm. Okay. That's interesting because I've heard this argument, and it even relates to the compact that the president, that was in your article too, right? Or was it?
I did. Yeah,
okay,
I did mention that.
I can't remember if I'm just like importing that into your argument or if I'm, okay. But like I heard this argument from the current VSG president in person, actually. I heard this argument, I think, also implied in what you wrote, which is, what was it, like 80-90% of the students voted not to, or that they would not like to see the school join the compact.
Yeah.
And my counter argument that I generally provided is this school's not a democracy, nor should it be exactly. Like the whole purpose. This is, feel free to push back, but like the whole purpose of the school or of going to a school is that you have people, teachers, adults, to put it succinctly, who have knowledge and who are going to impart that knowledge into you. And you are the students are the ignorant ones coming here, and we're being downloaded knowledge into our brains. It would seem to be a natural extension of that what we say in a very serious sense doesn't really matter, because I'm being very blunt here, but like, because we're like uneducated or becoming more educated, but like we're coming here to learn things, right? So it'd be kind of backwards if the students became the I'm sure you get what I'm trying to say.
Yeah.
I guess from a similar point of view, in response to institutional neutrality, isn't there sort of the idea, and again, you can push back, that the school is doing what it sees as being most prudent for allowing us to have the best or the most proper educational experience that we can have, and like if they don't want to maintain a very democratic or consistent or any of these ideas that we as students might want, that's okay, because they're doing their job as being the trustees of our education.
Mm-hmm. I do. Yeah, I see that argument, because I think the key is consistency, where if the university is going to argue that it's in the interest of institutional neutrality to kind of, I don't want to say suppress, because that's like sharply worded, but to just insulate itself from the opinions of the students and student government or whoever, then I think that would make sense. But I definitely would ask that they preface that opinion and make it very public and clear that that is going to be their policy, because I can't really come up with concrete examples, but there are definitely instances where it's insinuated that students have a voice and
that's fair enough.
And
I mean, the fact that we have a student government, I think,
exactly.
is an example of that.
Yeah, so I think that's definitely the insinuation that students should have a voice and they should be able to contribute to the decisions made by the university, even if it's not like the very top vital decisions.
Right.
But but I do think that if the university were to say that it is within their range to just completely ignore the opinions of the students, and they did preface that, then that would make Vanderbilt probably a lot less attractive as a school, and people would not be.
And I should clarify, I was speaking very, very bluntly just to get the point across, but like what I'm actually thinking of is more like, I don't know, I can't remember what the act was called or whatever it was in the 19th century that gave Parliament more power in England. But pre that period, what you basically had in England was the king really had, actually today, technically the king still has all the power, but he delegated some of the power, like in the King George era and maybe before, to Parliament, right? Mm-hmm. And House of Commons, House of Lords, right? And it was just like, oh, what do you commoners, House of Commons, right? What do you commoners think, right? And he'd like listen, and they'd pass some bills, and he'd like take some of them and maybe not take some others, right? And at the end of the day, he's the king. He's the sovereign, right? Whatever happens at the end of the day is up to him. But he still has an ear out to the people as an act of prudence, right? Because if he totally ignored the people, he wouldn't have a country for much longer. Likewise, if the administration here totally ignored the students and made that point of doing so, as you just said, like we probably dropped from number 17 we're now to 517, right? And we lose our fire ranking, right? So that I think that was more of the idea.
That does this is like not exactly analogous, but that does remind me of like virtual representation, where it's like the colonists or the parliament members are telling the American colonists that they're representing their interests, and they're asserting that they do have their genuine interests in mind, and then turns out they didn't really, and that's why the colonies revolted. But I don't think my point is, I don't think there's any kind of guarantee that the administration will actually listen to students. And if they want to say that they have the prudence and superior knowledge, I think that would make more sense. But I don't think they can claim to represent the students without actually having like democratic kind of institutions in place.
And I think what's difficult is because of the way our world is now with this, we're very, I mean, I'm kind of getting into political philosophy here, but that's VPR podcast episode. But like, where we live in a very democratic age, by which I mean, I'll say this: we live in a very egalitarian age, right? In which, if I were to make the point, like more publicly, that no, I think that the administration, by virtue of the nature of university, like we come here to learn, right? We come here to look up to the people who control the school and the professors too, like that whole body of people, right? By nature of the situation, we are inferior to them in this regard. And should listen to them, and we should assume that they have our best interest at heart, right? And we should operate under that assumption, and thus we should let them make decisions for us completely, which basically is what happens. But if I were to come out and just like say that affirmatively, I feel like a lot of people in this very egalitarian age would be like, that sounds like hierarchy, and that sounds like, you know, that even the language of inferiority and superiority is very touchy nowadays. Yeah. So I think you make a good point that, you know, it's difficult to maintain the language. It's very nice. The nice language everyone likes to hear about, like, we listen to our students, you know. Yeah. We're open, we're accommodating, like all these nice phrases of you know, modern, I would say, just broadly liberalism, right?
We don't have to get into a Deweyan argument about like the institutions should be democratic to encourage like participation among the people.
I mean, like, again, I think that's going to my point about just like how a lot of our notions around what institutions should be like is wrapped up in this egalitarian, post-enlightenment, liberal in the political philosophy sense, not just like left-wing American, even though like they're all anyway. But any more in this article, or do you want to move on to your second article? I'll let you kind of drive this part of the conversation where you want to aim it at.
I think we can move on. I think we touched on it a lot.
Yeah, sure. So I guess I'll just have you summarize your second article on generally what that was about.
So I wrote this. I was looking at the Skrmetti case primarily, but I was also just, to be honest, I hadn't really read up on a lot of these cases before actually writing it, but I had heard fragments of different cases, and this was right after the declining of the Obergefell revisit petition, where people were concerned that gay marriage would be overturned, or based on the petition that Kim Davis made out of Kentucky. And I never really thought that it would actually be overturned, but I think it was worth looking into because I feel like it was, in a way, celebrated as a kind of victory, even though really nothing had changed. It's kind of the continuing of the status quo. And a lot of these decisions, like Skrmetti, didn't really get much publicity, in my opinion. But just reading the arguments and the summary from the case, I found it very kind of problematic because basically a lot of the arguments the justices were making were depending on this assumption that transgender Americans are not like a classified or a discrete group of individuals historically, or based on like the Equal Protection Clause. And I think that's very like dubious argumentation, because I think that transgender Americans clearly have a historical precedent of being a group, and they're uniquely affected by targeted legislation. So I feel like I just have that issue with the decision. And then I was also looking at this case that had to do with religious freedom. I'm kind of forgetting the name of it. But basically the idea is that you can opt your kids out of any books.
Is that Maryland?
I think so.
Okay.
That may discuss like gender or sexuality based on religious grounds. And I think that is a pressing issue, but maybe not as monumental as the Skrmetti ruling. And I think the religious freedom issue probably has a better case in court, even though both of them had like successful rulings. I feel like I can see that argument more succeeding in court, but I do still disagree with it personally. I think it's harmful. Okay. But then, yeah, and so I was looking at those cases and kind of
sure. Yeah, so I guess we can look at the discriminating one first. So I guess like your main, and I'm gonna be a lawyer, so this is right up my ballywick, right? Your main concern with Scrimeti and its legal argumentation was the protected class or the lack of protected class status granted to transgender people. And I guess I'll be obviously like I agree with Scrimeti, right? As you were saying before. Surprise! Also, like surprise! If you guys don't know, I used to be the College Republicans president here, so I always preface these episodes whenever I get into topics that I obviously have a very clear opinion on. That's where I'm coming from as the host of the podcast. So in full transparency, but I guess I'll just give you my take on it and let you respond to it. Basically, my thought is, and I think Amy Coney Barrett made this. I don't know. I'm not going to assign it. I'm not sure, but basically, the idea of a protected class isn't only that group must be identifiable or understandable as an actual class, right? Like that can be the case, but the protected part needs to also be there too. So, like, is this group based on the merits or based on the situation worthy of protection? I know that sounds like but let's be legal about this. Like that's the idea, the legal idea behind it, right? So, for example, like a class of people might be children, just in general, right? And they're certainly worthy of protection in many regards, but like if I came to court saying, kids should have a right to, like this place says only 21 up, right, or 18 up, right? And let's say like it's not even like an alcohol thing, like a medical. It's just like it's like an adult only, not in a dirty way, just like an adult club. Like that's bad. I can't put it in a nice way, but like an adult only space, right? And you're like, well, like kids should be a protected class or a class of people, and that's not equal, right? And obviously, you'd be like, okay, but like they're kids, like there's a real. They shouldn't be protected in that way because there's a real underlying difference between adults and children. This is kind of obvious, right? Yeah. But I'm just laying that out to make the point that, if the claim is to be accepted that, transitioning children, I mean, just to be rather blunt, is not a valid thing to do, right? Like, if that claim's accepted, right? Okay. Then the protected class thing also necessarily falls, which is all to say that, like, I think this question just falls back on the fundamental question of whether you can or cannot transition a child or a person in general, or even the less heavy question of maybe transitioning is an option one can do later, but it's similar to getting a tattoo or similar to doing other things that you have to wait till you're an adult to do. Even if your parents are okay with it, like you can't give a 6-year-old a tattoo, even if mom and dad says they're okay with it, right? Generally speaking, there might be some religious, but generally speaking, right? Yeah. I've been talking for a while, but just to be clear, I'm not trying to litigate right now on this podcast whether transgenderism is real or none of that. I'm just saying, as a legal reality, does it or does it not, in your opinion or in your view, ultimately fall back on those questions?
So personally, I think the argument at hand should be independent of most of those issues, but just to put in perspective, I feel like looking at how protected. Well, obviously, I know there's freedom of religion enshrined in the Constitution, but looking at how protected religion is in our legal system, I feel like it's not obvious to, like, religion is not something you're born with exactly. You have to take someone's word for it, that they're a person of faith, and you have to basically take their word for it. But yet we still believe that they have a religion, and that makes them entitled to legal protection on the grounds of religion. So I think these arguments that are saying, I know this is not totally relating to what you said, but these arguments trying to basically deny transgender people legal protections don't really hold up to me, because I think in my opinion, they're pretty clearly a discrete group that has faced legal discrimination. And I think if we just look at the spirit of equal protection, that is basically, I think it is very much against the spirit of equal protection to deny transgender people specific rights.
And what is that spirit in your view?
In my view, it's just protecting minority groups from being oppressed by basically the hegemonic culture or just the governing.
To be
party.
subsumed by the majority, I suppose.
Yeah.
I guess my question would then be, obviously I would imagine that you view the transgender claims as being valid,
yes.
right? But I guess the question would be like, could you see the problem with that sort of characterization of the whole situation from the perspective of someone who sees it as invalid, right? So how about this? I'll give an example of a thing or a class that would obviously be very dubious. Let's say there was a group of people who, I don't know, what's a crazy example I can think of that's like obviously crazy. Even a religious group. So you rep religion, because even like that's not infinite. That right to that freedom, right? Because if your religion says you have to some like cults, like legitimate cults that are like putting women in sexual slavery and stuff like that, or murdering people, right? If my religion that I made in my backyard 2 days ago says I have to go and kill 10 people for Gooba Gabagloo, like the god I just made up in my head, right?
Okay.
I think and there's actually precedent in this. I can't remember off the top of my head, but like there's bounds to that too, right? There's a real sense in which you can say, okay, that's not a real religion, The Gooba Gabagloo religion I just made it in my head right now is not the same thing as Christianity or Hinduism or Islam or any of these real religions, or even Mormonism, right? Just to make the point that it's not like a temporal thing. And like Mormonism came up, obviously, it's one of the youngest new religions in the world, I would say, or even Scientology, right? Although, anyway, but I'm not gonna go there right now. But you see my point, right? It's like if it's just this question of, are you a discrete group that is a minority and can in theory have your interest encroached on by the broader culture, that can begin to, or that opens the door to protecting some groups that quite frankly ought not be protected. Do you see the concern there, and how would you address it?
I do see that concern. I suppose. Well, I see where you're coming from. I don't necessarily agree, but I do kind of think that if some protected groups that we already have, like for example, gay Americans, I don't really see how it's really a jump to go from protecting gay Americans to protecting transgender Americans. And there has been a Supreme Court case that has argued that transgender people should be protected under the word sex, and I think it was the Civil Rights Act, and which also pertains to the 14th Amendment and equal protection. But yeah, so I would agree with that interpretation, but even setting that aside, I think that it's pretty clear throughout history that transgender Americans are a discrete group. And I feel like in a way denying that they are is kind of just like, I don't know, just ignoring.
But just to clarify, I don't think anyone's arguing that they're not a discrete group.
Okay.
I think everyone's like, it's like, duh, like, okay, we're saying adjective before another adjective, like that's the subgroup of the main group Americans, right? Okay. Like white Americans is a group, black Americans, like if I can say blank Americans, that's a group, right? More or less. I think the argument is just whether or not it's the word protected, right? And whether in this way they're worthy of that protection. And I know that sounds I'm being very clear here because I don't like dancing around the question, and like the question isn't like, obviously if there's an incident, for example, in which a transgender person is like assaulted for being transgender, that's not what we're talking. I think everyone would agree. Okay, don't assault people. Like charge that person with assault and call it end of the day, right? I think what we're talking about here really is, should they be protected constitutionally from the state or the states individually infringing on their ability, or what you might say is a right? I would say it's an ability or will or desire to make good on their transgender identity by doing XYZ procedures. That's really what we're talking about here, right? Because again, I think if it's a matter of like, okay, should you be able to like harass, or of course not, right? And I don't think that's what people are really talking about here. So I'm not sure if you would accept that clarification or not. Would you? Or
well, I see what you're saying. I think independent of the discussion about surgeries, even though I do have my opinion on that, I think that like transgender people should be a constitutionally protected group, like regardless of that, just because. Well,
so what does that mean to you? Like to be I guess this is a better question. Like when I say transgender Americans are a constitutionally protected group, what does that mean practically on the ground?
Well, I mean, just any protections afforded by the Civil Rights Act, I guess, like discrimination in workplace and public spaces. That.
So, for example, that would apply to, I guess, the renewed ban in the department or in the military on transgender service members. Even so, will that be the case? Even though the argument is, are you aware of the argument specifically that DOD or DOW makes? So the argument basically is just like, you know, if you are a transgender person, your healthcare costs are, I mean, at times significantly higher, because I mean, like, I believe it's still considered elective, and for a lot of insurers and whatnot, and just generally in healthcare, and it's not. And I would agree with them on this. Maybe you disagree. It's not medically necessary. In the majority of cases, I would say, at least not medically necessary in. From the perspective of the military, who's like, for medically necessary for the military, it's like, okay, we need to patch you up and get you back on the battlefield. So medically, it's not just like generally, like what we would consider, like their bar's a little lower for medically necessary because it's the military, you know, I would imagine just generally. So would what you're saying implicate that and say you can't even make that argument because they're a constitutionally protected class and they have to be allowed into these spaces, just like how the Civil Rights Act said, like blacks have to be allowed into these white spaces?
Yeah, well, what I would say is, or
bathrooms too, just to give you more to talk about.
Okay, well, personally, I'm going to lean to say that the government, like, I'm going to lean towards saying that I would support them funding those procedures because I do think they are very critical and necessary, but I do accept arguments saying that it's not the role of the government, and I do understand where that's coming from. But either way, I think the cost associated with gender reassignment surgeries and procedures along those lines does not justify the government banning all trans individuals from military service. If they truly believed that argument, they could just refuse to pay for it and then still allow transgender individuals who want to participate regardless into the military. But there is a blanket ban, so I think that's definitely a step further. Right.
So I guess my follow-up would just be, is that concern a constitutional concern or is that a policy concern? Because I see this conflation a lot where people, I mean, I would say really since the Burger Court and the Warren Court, like the mid-20th century courts, right? There's this, I think there's been this misuse of the court such that people are just, and really the court is just shoving through policy prerogatives, right? That's the wrong word, not prerogatives, policy desires, let's keep it simple, through the court instead of being strict on the whole constitutionality sort of thing, right? Because I would say what you just articulated right now vis-a-vis the military would be like, fair enough, argue that as a piece of policy in Congress, right? But I don't see how that connects to the Constitution. Even the Civil Rights Act is just is an act. It's not even part of the Constitution, right? And maybe like insofar as the court's going to say there's a problem here, it's in violation of the Civil Rights Act, but it's kind of dubious in and of itself because the Civil Rights Act obviously wasn't written in the context of transgenderism. Any reading of it being implicated in Civil Rights Act transgenderism would be a reading into the Civil Rights Act, I would say. Point being, do you not think that this is really, at the end of the day, just a policy concern over a constitutional concern? Not to be all originalist or everything, but like it seems kind of like I don't think the framers were thinking of transgender Americans, nor do I think the broad ideas they were talking about just by the way things have progressed necessarily implicate transgender individuals.
Well, I maintain that this definitely is still constitutional because I think looking back at the history with gay Americans in particular, it definitely was seen as more of a policy issue at the time rather than a constitutional issue when homophobia was a lot more normalized. Mm-hmm. And I honestly think it is kind of society not coming around to view transgender people or gay people in the other case as a prejudiced group who is discriminated against, because like the longstanding view was that gay people were not a valid group and that they were just like an abomination basically. Mm-hmm. So I think that informed not seeing the issue as a constitutional issue. And obviously when the founding fathers wrote the Constitution, the rights of gay people were not enshrined in the Constitution, but we've come to decide that in America, where gay people are not protected for their identity, is basically has completely abandoned the ideas of equal protection and equal opportunity. Right. So I think that it should be a constitutional issue. And even though it might be framed as a policy issue still, I hope that the government will evolve to view transgender people as concerning like a constitutionally protected group. Sure.
I'll push one more time and then we can wrap up. Okay. I guess a two-parter here. You were saying that obviously when the Constitution was written, the rights of gay Americans weren't considered, but then we came about to doing so, and we should have done so, is what you're saying. Mm. We should have made that change, but it isn't like wouldn't the proper mechanism for that either be legislation or, I'm kind of repeating myself, I think it's still a worthy question, or an amendment, right? Because you kind of admitted yourself, like it's not there, right? But on the flip side, I guess more sympathetic to your view, if we are going to allow cases like, like a Bergefell, like even Loving v. Virginia against miscegenation, even though I think that could, I'll just say it really quick. Like, I'll put this out really quick, and then I'll let you actually respond, then we can wrap up actually, because this is like kind of like my whole thing with that era of stuff, right? Like I have to reread it, granted, so I won't put that out there, but based on what I know about Loving and a lot of the cases like it, right? Mm-hmm. I don't think the logic holds up very well. Sort of like Roe. Like Roe was probably the worst in terms of the logic. Even Ruth Bader Ginsburg said that the logic of Roe was pretty bad, and they could have anyway. But like for example, I would have got to a similar result in Loving v. Virginia through privileges and immunities, right? Saying that, and then like just history and tradition too, which is also like a softer standard, saying that, first with history and tradition, like people have been getting interracially married, not like en masse, obviously not, because then you'd lose the races, but forever. But like forever, like it's been read the Bible, it's there, you know. And with that being said, with that being almost not a natural right per se, but a natural human thing, by a given state saying you can't do that, and another given state saying that you can do that, and it's trampling on the inherent privileges and immunities one ought to have as a human, right? Yeah. Less an American. Mm-hmm. But this whole like using the 14th Amendment as a Swiss Army knife, I think becomes rather dubious, because the 14th Amendment wasn't written to do any of this. Equal protection, from what I understand, it was really meant to say that the law equally applies to everyone, basically, and equally protects everyone, right? And should not be written in a way to, I guess kind of what you were saying, to disenfranchise in the most general sense one's being, right? In the obvious context of slavery and black people, let's be quite frank here. But I think the problem is it's been used as a Swiss Army knife, and this is what I was going to bring up. Bergefell, like regardless of like whether or not you think like gay marriage as a thing is okay or not, right? Like, who said it that like Justice Kennedy was just making up poetry in that in the decision? I think that might have been Michael Knowles. But I agree. It's like it's just not there, right? This idea that the states cannot, number one, history and tradition is not going to defend that because obviously marriage as a traditional institution up to that point, privileges and immunities thus fails because of that thing I just said, because of the history and tradition test fails. I'm kind of rambling here, but I guess my point is just like, is this just an example of the courts just having too much power in declaring things constitutional or not, using the 14th Amendment between due process and equal protection as this utility enough to do whatever the hell they want, you know? And would we be better off, I guess just generally speaking, would we be better off by just relegating stuff like this, as they're probably meant to be by the framers, to questions of either just national policy by Congress or just state policies, and let the states do what they need to do, especially in a social sense. And then I'll leave it there. I know I've been yapping a lot this episode.
Yeah, I'm going to try not to go back too far.
Sure.
But I think it is interesting because what you said about the institution of gay marriage, there's like, I would argue that there is more of a history of transgender people than there is of the institution of gay marriage. If you look back at like Roman Emperor Elagabalus, all this different historical aspects where there are individuals who tried to change their gender.
Are they exceptions though, or like, are they the exceptions that prove the rule? In term, again, the question here isn't whether they're. I'm sorry, I have to clarify this. The question isn't whether they're a group or not.
Yeah.
The question is whether, like, for interracial marriage, for example, right? Like, it would have been one thing if people secretly got interracially married for like all of history, and those were the exceptions, and they're always ostracized. It was never okay. My point with interracial marriage was that not only like did they get married, not only like was it a thing, hence group, right? But like they got married and it was just like, okay, you're married now, right? Like, and it wasn't like at times obviously it was scandalous and obvious, you know, but like, you know, it was protected, right? So I just want to make that clarification before we continue. Make sure you know what I meant.
Okay, I was just going to finish that up by saying that in some ways we kind of selectively see what we think is the tradition of history and based on like progressive issues, what we now call progressive issues, because in many ways Americans have turned a blind eye to gay history and trans history, and just basically the entire world has turned a blind eye. So we don't see as much of that history and that linkage compared to other stuff like what you said, like interracial marriage. But then, with the whole issue of the courts, I think it can be like a double-edged blade, because you do have these really progressive rulings like from the Warren Court, like Brown v. Board, and all these different rulings that extended rights to oppressed Americans and helped extend equal protection. But then now that same level of judicial activism where courts can decide whatever they want without input from Congress or the people, now you have rulings that even liberals would disagree with, like Chevron and all the recent rulings. So in some ways, I guess you just have to take the bad with the good, because the Supreme Court is supposed to be insulated from political pressure and make decisions based on the Constitution, regardless of your opinion. And we can probably push back on that. But I definitely agree with the tradition of equal protection in the 14th Amendment. And I do think that it was necessary to protect all these different groups stemming from the 14th Amendment protecting recently freed slaves who were being discriminated against in the South, because it was protecting them from discriminatory laws. So I think, and based on the language of the amendment, since it included other groups, it makes sense that it would go on, that the Supreme Court would go on to interpret that it led to the protection of other classified groups. And then in the spirit of that, which I guess becomes a little more dubious, and it's been extended to gay Americans and transgender Americans, even though you can find like parallels in the exact text with like the word sex or gender, and that also has to do with the Civil Rights Act. But so I would defend that legacy, but I do see arguments about flaws of the Supreme Court and having this power that's not necessarily checked by Congress or voters. And I do kind of cast doubt on the idea that they're very politically insulated, or that they're truly this like objective body. And
yeah, it's ridiculous.
Yeah.
I mean, we're humans. Like this idea that humans can be objective is ridiculous,
Yeah.
right? No, let's to be clear, like there are objective things that humans can realize and speak of. At least I would say. I do believe in objective morality and reality. But the humans, like we're subjective. So yeah, I agree with you on that. Like the court's going to be objective. No, they're not.
Yeah.
But anyway, Darren, did you say your last name again?
Kellis.
Darren Kellis.
Yeah.
It's good to have you. Welcome to VPR again as a freshman.
Thank you.
And I hope you stay on until the time you're a senior, just like me, all old, and people are calling me Unc now. Which is like, don't call me that, but I guess I'm in my last semester, so that's exactly what I get. But anyway, thank you for being on.
Thanks for having me.
Yeah.